All right, everybody, we're going to start in about 3 minutes. Let's see here. I hope everybody's having a good week so far. This should be a pretty interesting presentation. I see that the contract volume has picked up, so knowing which form to use is going to be super important. Hey, Mike, how are you? Okay, well, 1 more minute, we're gonna get started. And like I said earlier, we're gonna go over the FAR and the NABOR contracts. I've got slides, so you don't necessarily have to have them in front of you. But if you want them, I'm gonna use the regular contracts. You can pull those up as PDFs or print them out. Morning, Ginny. Morning, Sabine. Hey, everyone. All right, everybody, it's 10 o'clock. Let's get started. Dive right into this NABOR versus FAR contracts. Which one should I choose? We're going to talk today about both the standard FAR contract and the residential improved property contract by NABOR. We'll discuss a little bit about the as-is contracts. Now, because I'm an attorney, we always start off with a disclaimer that this is not legal advice and we don't have an attorney-client relationship, but you are always welcome to call me, email me, or text me, and we will get you taken care of, whatever you need in terms of legal work. A little bit about my firm. It was founded in 2007, and we focus on real estate and business law. So this really is what we do. And we help everybody in the real estate business, realtors, small business owners, entrepreneurs, buyers, sellers, property managers. We also offer full service litigation. So deposit disputes, landlord, tenant, things like that are always, we handle those in our office. For my part, I've been an attorney since 2003, so I'm right around 20 years in practice, and I focus on real estate and business transactions. I am on the NABOR Legal Resources Committee. Actually, this year I'm the chair, and I'm on the reptiles, the bar reptile sections real committee, which helps with the FAR contract. So I know both these forms that we're going to go over today. I'm looking forward to this. A little bit about today. We're going to compare the contracts. We're talking about the pros and cons of each one. Like I said, I'll be using the main contract, and I'll discuss the as-is. And I've got slides that talk about the differences, and I'll point out similarities as we go. So diving right in, the first thing I want to bring up, of course, is that, these contracts are the tools of our trade. So it's important to know both forms, the NABOR, the FAR. Both have positive attributes, both have some concerns, and really who you represent and what you're trying to accomplish determines which contract you should pick. So I will get questions like, which contract is better? Well, there's no particularly better contract. It just depends on which side you're doing, buyer or seller, what county you're in, what the issues are, how strong is the buyer's financials in terms of financing, you know. And you could say things like the FAR contract has much more exacting,
Oh, wow.
cumbersome financing provisions, but the NABOR contract has much more exacting inspection provisions. So it's not really one is better than the other. It's just which side you represent and what are you trying to get done. So let's start at the top of the contracts and let's go right down from there. We'll talk about the differences. And if you've got it in front of you, though you don't need it, we're right there on the top of page 1. First thing is the property description. Very simply, in FAR, you do not get a washer and dryer. In NABOR, the washer and dryer specifically convey. FAR has a general language about built-in appliances and built-in furnishings, whereas NABOR has a comprehensive list of all the items that convey, and that's basically all non-leased property. As far as the built-in furnishings and appliances go, I would say that under both contracts, the way they're written, anything that's screwed or glued would convey. But you always have to look to your specifics for things that are not screwed or glued. And of course, the washer and dryer is the big item. But like now, FAR has it so it's similar to NABOR, where television mounting hardware and mailbox keys, access devices are included now. Both contracts have added that smart home features convey. That's fairly a new addition to both contracts. So be wary of what your smart home features are. One big difference that I like in FAR is that it adds the property identification number. But the NABOR does not have a space for the PID number, but it's not needed. What you really need is the legal description in both contracts. NABOR has a space to add the parking spaces, the garage spaces, the amenities, etc. Whereas in FAR, you wouldn't put those on the main contract. You put those on the particular rider for the homeowner association or the condominium, depending on which one you're selling. A couple of things, NABOR has an exclusive list. So if it's not listed in the NABOR contract, it does not convey, whereas FAR again has the general built-in appliances and furnishings, makes it much more general. So you get just making sure you know what you're selling is probably the theme of the first slide. When it comes to offer and acceptance, FAR looks for signed and delivered, whereas NABOR is the last date either set forth in the contract by either party as the effective date. So you got to be very careful to make sure that you deliver the contract to the other side, the final fully executed contract in both contracts, but the effective date is not the same. So if you were to miss if it was late at night to get your acceptance done and you didn't get the contract over until the next morning, under FAR, the next day would be the first day of the contract, whereas under NABOR, the day it's signed is the first day of the contract. So you got to be very careful there when you're counting your days, especially if you're doing these 7-day inspection periods. Every day counts. The other thing about FAR is it defines closing now. This is a new feature. It happens when all the funds and documents are received by the closing agent on the closing date at the time decided by the closing agent. Whereas NABOR does not define closing, it just happens on the closing date in the county where the property is located. Typically, though, the best practices and the standard practice, I should say, with closing agents is the closing occurs under both contracts when we have all the documents and all the money and all the loan approvals on the closing date. Now, of course, the closing date can move around a little bit, and there are different places in the contract that change the closing date. The cure period and in FAR, the clearance period in NABOR. But one place that's both the same is the Consumer Financial Protection Bureau period to move the closing date on a finance deal. FAR used to also be 10 days, but now it's only 7. So be mindful of that. And then on the NABOR contract, it's still 10 days for the Consumer Financial Protection Bureau. Basically the period where the CD is produced and sent to the buyer to sign 3 days before closing. They give 7 and 10 days extensions for those. The next big change that's different between the two contracts is the assignability provision. This comes up a lot if you're using investment property or really anytime you want to assign the contract to either a sibling or a relative, or again to an LLC or to a trust. You want to make sure that you understand the assignability provisions, and FAR has checkboxes, and there are 3 choices: to assign and release the buyer, assign but not release the original buyer, or not assign the contract at all. And the default under FAR is that the contract is not assignable. So you got to be careful there, because the default under Florida common law, if you don't say anything in the contract, is that the contract is freely assignable. So they changed the common law default in the FAR to say you cannot assign it. And that's to protect your seller so they know what they're dealing with. Under NABOR, the contract is freely assignable up to 15 days prior to closing, but the original buyer is not released. It's not released from liability. So you may have 2 people you can go after if you're the seller and the contract has been assigned. And then now, as far as the mechanics of assigning a contract, under FAR, there is no form. So you're going to get your favorite closing attorney to prepare a formal assignment document. Typically it's 1 page, and it simply says that the parties agree to assign the contract to the new buyer, and the old buyer and the new buyer sign. And then you might want to put on that assignment about the release of liability, whether it's the original buyer is going to be released or not. Under NABOR, there's a form, makes it very easy. It's signed by the old buyer and the new buyer, and it clearly states that the old buyer is not released. Any questions about assignability of the property? Oh, this is the easy stuff. So the next big difference, of course, is how you pay. And really, we could call this the start of talking about financing on a cash transaction. It's interesting, under the FAR contract now, it used to have language that contemplated financing, but the new FAR contract just says this is a cash transaction with no financing contingency. So if you check the box for cash, there is no finance contingency, there is no CFPB compliance window, and if you miss the closing date, or really any date, we'll talk about that more, but if you miss the closing date, you lose your deposit. Under NABOR, if you check the box for cash, you can still get financing, but there is no CFPB window to comply, and there is no contingency for financing. So you have to hit the closing date, because closing date time is of the essence in the NABOR contract. And we'll talk more about time is of the essence in detail in a few minutes. So just be careful under cash. It's FAR says no financing is contemplated. NABOR allows for the possibility of financing, but there is no contingency. So what do you do when you do get financing? Well, there's a lot of differences now between these two contracts. And ever since the Florida Investment Group LLC versus Lafont case, which I'm going to talk about in a minute, FAR has got some interesting provisions. They have a 30-day loan approval period. That's the default. You can change it to more or less. The appraisal contingency is now part of the loan approval in the FAR contract. So it used to be that FAR, you could get a loan approval, but then get out of the contract if the property did not appraise. That's no longer the case. And under NABOR, the default is 45 days to get financing, and the buyer or seller can terminate if no financing is approved. And there's no discussion of the appraisal in the NABOR contract. You simply get the property appraised, and you don't waive your finance contingency until you are clear to close under the NABOR contract. Under the FAR contract, You have to use a diligent effort in good faith under both contracts. But they define diligent effort as paying for the for the appraisal and getting all of your documents to the lender. And if you can terminate the FAR contract before the loan approval period ends. Once the loan approval period is over, then you cannot terminate. The seller gets 3 days to terminate if you haven't waived the contingency. And if the buyer doesn't close, they lose their deposit. Whereas under NABOR, the buyer has to affirmatively waive the contingency in writing, or they get to keep their deposit even all the way up to the closing date. Although you got to be careful there, because NABOR, I would argue, if you did get loan approval under the NABOR contract, then you would have a tough time saying that you exercised diligent and good faith effort, but were not approved, and maybe you would not be able to terminate. Although NABOR is unclear about that, so we'll always have a little back and forth. I did mention the Lafont case. I kind of described the Lafont case as a Scud missile seeking to destroy the buyer if they don't get the proper financing. So this case is interpreting the old FAR contract. We are now in FAR version 6. This Lafont case was FAR version 5, and it is the reason there is a FAR version 6 contract, but it applies equally to NABOR contracts. So I'm bringing it up here. Basically, what this case says is if you don't apply for the financing that you state you're applying for in the contract, you're in default and you don't get to terminate and you lose your deposit. The court, I'll use the word hinky, did some hinky things, did some interesting things to get to this result, but it is the result they reached. So in both contracts, but definitely under the FAR contract, if you're going to change your financing terms, please make sure you do an amendment to contract and adjust the contract terms to meet the new financing. And if the seller does not agree to the changes, then the buyer should seek to terminate the contract, because otherwise they're going to lose their deposit. Any questions about financing? I know I said a lot. Bob has a question. Under NABOR, does the buyer need a low appraisal to get out of the contract and get the deposit back? Bob, under NABOR, the buyer can terminate if they're not approved, or if no approval or denial has been issued by the end of the contingency period. It's not necessary that you get a low appraisal, but that certainly would help. Mia, can we get a PDF of your presentation? Yes, Mia, we're going to send this out, all the slides, to everybody. Everybody after the presentation is over in a few hours. Cheryl is asking, was that case from a NABOR contract case? No, Cheryl, that was Lafont is a FAR case, but the way it's written, it would apply to either contract, in my opinion. Other questions about financing? I know it gets confusing in both contracts pretty fast. If you just change the lender, does the buyer have to notify the seller? Batia is asking. Batia, I would say no, because it does not change, if you don't change the terms. Like if you go from a 15-year to a 30-year, or the interest rate is going to be different, or it's FHA versus VA versus conventional, whatever it states in the contract. But if you just change lenders, I don't think you need to notify the other side. Ann is saying, so if the appraisal is low and the lender still approves the buyer, they must move forward. Is that correct? And that could be correct. I would argue that's the case under the NABOR contract. If you get a loan approval, I think it's pretty tough to terminate the NABOR contract for loan under the loan financing contingency. But again, the NABOR contract is unclear on this point, and we're going to have to work on that in the committee. And Mary Ellen says one of my slides is missing the word no on FAR contingency. Mary Ellen, I will take a look at that. All right, let's move on to HOAs and condos. So very interesting difference between the contracts. NABOR contemplates that you're going to be in an HOA or a condominium, and they put the language that's required by statute right in the base of the contract. On FAR you have riders that you have to use, rider A for condos, rider B for the HOA. And I cannot emphasize this enough. If you sell a condo or home in a homeowner association, please use the correct rider. I see it all the time where people just make these as-is contracts under FAR and they don't use the rider. Well, if you don't use the rider, then what amenities convey? Is there an approval process that the buyer has to go through? Getting the estoppel information for the seller. All of those things are in the riders. So under FAR, please make sure you use rider A or rider B for the appropriate association. Under FAR, using the correct rider, you see that the approval and right of first refusal is disclosed. NABOR, there is no discussion of right of first refusal, but if it comes back that there is one, you have to comply with it. Under FAR, you can disclose the association fees on an addendum. NABOR, we do not disclose the association fees except for on the HOA, the required HOA disclosure statement. And the way they do assessments is slightly different. Under FAR, special assessments are negotiated and you check a box on the riders. Under NABOR, the seller pays all special assessments due before the effective date, and the seller pays pending assessments if they're not properly noticed prior to contracting up to 1% of the purchase price, or the buyer can terminate. Okay, Cheryl is asking, what if the HOA management company does not supply the docs needed for condo to meet the statutory requirements? Then the buyer can terminate, Cheryl. If the buyer doesn't get the required condominium documents, and you say HOA, but I assume you mean condo. If you don't get the required condo documents or you don't get the required HOA disclosure, the buyer can terminate until 3 days after they get them. Mike is asking, if a condo association is a member of the HOA, do you still need the HOA disclosure summary? Mike, that's an excellent question. So in the condo statute, it says that you do not need the HOA disclosure summary if your condominium paperwork contains the information for the HOA. So it depends on the association. To be safe, Mike, I would say in pretty much every case, just do the HOA disclosure. I know it gets confusing and it gets frustrates some folks to have to do condo and HOA disclosures, but it just makes life easier. It's not the panacea, but it just works. Let's see, make sure I don't miss any questions that are coming in here. Cheryl's, anything you can do? Cheryl, the thing to do is the seller needs to request the information from the association, because the association is required to respond to the seller. And actually in the FAR contract, it says the seller shall initiate the approval process, which means the seller should go get the information packet from the management company and take it to the buyer, and the buyer can fill it out and make their application with the required documents. It's very difficult. Guy says, please define pending. Well, Guy, pending is an amorphous concept that NABOR has in place. FAR, by the way, with regard to pending assessment, says that if it's anything that's been mentioned in the minutes or the agendas for the previous 12 months, it's pending. NABOR does not do that, but I would argue that that's an effective test for pending. What it really means is, as realtors, you need to know your communities. You need to know the communities that you sell. If you're selling in the Aria condo, go through and understand all that's required to get that done in that condo. If you're selling in Gray Oaks, understand the Gray Oaks requirements and what has to be done there. It's really incumbent on you, the realtor, to know how to get the documents, how to know what's coming down the pipe by talking to the board of directors, the president of the association, the management companies about your associations. And I know management companies don't have time, don't have an interest, don't want to talk to you, but they really do have very useful information that if you can extract it from them is going to be very helpful in your business. Francis is asking if you can start the application without the contract. Francis, I'm gonna say that's association by association, but typically you need a signed contract to apply. Guy says, do associations have to have minutes, etc., with the buyer, share them? Guy, they don't have to do anything with the buyer. That's the problem. The seller's got to start the process. So it's very difficult. The seller's got to get the associate, and like I said, FAR contract specifically says the seller shall initiate the process. Okay. Deborah's saying, how do you incentivize the association? Deborah, you don't incentivize the association. If they don't want to cooperate, then they're going to lose sales and their values are going to go down. That's really all there is. Wendy's asking about calendar days versus effective day versus business days. All the contracts, Wendy, are calendar days for everything until 11:59 p.m. Okay, moving right along in the presentation, we're going to talk about title insurance and who picks and pays. So under FAR, you check the box for who picks and pays, buyer who picks the owner's policy. In both contracts, the buyer pays for the lender's policy. But in FAR, you check the box for who pays for the owner's policy. The lien search, which is different than the title search, we can talk about that later, follows the title insurance under FAR. Under NABOR, the buyer picks the title agent regardless of who pays for the owner's policy. Like, this is very frustrating to folks in Lee County and Charlotte County who use the NABOR contract, and they realize that the buyer picks the title company in every case. And there are no options in the in the NABOR contract, sorry. The seller pays in Lee and Charlotte, and the buyer pays in Collier. And the buyer always pays for the lien search on the NABOR contract. Interesting point, more relevant to me is the title company than you, trying to get the inspections done and the financing taken care of. But the title commitment is due to the seller on different time periods. In this case, I rarely ever say this, but I will say the NABOR contract is better in this regard because the title commitment is due 10 days after the effective date, which means that the title company's got to get out there and get title pulled right away. So if there are problems on the title, you're going to know about it very quickly and we'll get them resolved. And of course, in my office, we're always working to get the title closed as quickly and as effectively as possible. Under FAR, the title's not due to the seller until closer to the closing date because you want to get through the inspection period. And the issue there is if something big comes up on title and it's going to take a while to get it closed, then you're into the cure period and the extended cure period, and you could go out 4 months under FAR. It's a pain in the rear. And so, like I said, in this regard, NABOR is better. Rosemary is asking, oh yes, Rosemary, I published a map a long time ago about who pays for title insurance. I will repost that to social media later today. Okay, inspections. So, hold on. So, inspections are very different under both contracts. We're going to talk in a little bit of detail about both of these. FAR, you get 3 inspections: the general, the wood destroying organism, and the permit. You can use the riders for lead and mold inspections. Under NABOR, you get 6 inspections: the systems and equipment, the radon gas, the lead-based paint, the WDO, mold, and open permits. Under FAR, there is a minimum threshold that you can enter into the contract where the seller must spend money. Up to 1.5% of the purchase price is the default, but you can put whatever percent of the purchase price you want. And that's for each of the 3 main inspections: general, WDO, and permit. So under FAR, if you didn't change the defaults, your seller could be on the hook for 4.5% of the purchase price in repairs. Under FAR, if the repairs to each one of the items exceeds the limit stated in the contract, then the parties have to notify each other, or either party can terminate the contract. And basically the notices say that the seller will make the repairs and move forward, or the buyer will take the property as is. And if neither party makes the appropriate notice, then either party can terminate. Under NABOR, the remedial action is a defined term that's much more expansive, I would say, than in FAR, but it's limited to the fair market value of the items in working condition. So there's a limitation on how much the seller's got to fix. They don't have to fix every little thing to perfection. They just have to get it into working condition. And there's the time periods in the NABOR contract are more defined, I would say, in terms of, or I should say expansive, not defined. They're more expansive, and you get 15 days to inspections, 5 days to gather reports, 10 days for the seller to respond to those reports. And if the buyer doesn't get a favorable response, then they have 5 days to terminate. And there are forms provided for the inspection process under NABOR. We have the inspection election form and the list, which is a love-hate relationship with some of you on the call that I see today. And then, of course, under both FAR and NABOR, you get a free look on the as-is contract. Stephanie is asking me, does the lien search handle the permit, and why is permit a separate inspection? Stephanie, yes, typically the permits show up in the lien search, and but except that we can always look in the permit portals for the cities and counties to see what is out there. It's not entirely comprehensive, but it's very helpful. And then this permit is a separate inspection because if there are open permits, typically buyers want those closed, and sellers are in a better position to close them. Talking more about, or Bob is asked, is there a counteroffer form for price or closing date change under NABOR? There is not, that I'm aware of, Bob. There's a closing date change, but not a price change. So yes to closing date, no to price. Okay. Talking about inspections, under FAR, your torn screens, your fogged windows, and missing roof tiles or shingles are defective items. Under NABOR, they are cosmetic items as long as there's no evidence of leakage or structural defects. In FAR, you can use dueling experts, which I think is a much better situation. If the buyer and seller don't agree through their particular inspectors under FAR as to whether an item is defective, that is, whether an item is not in working condition, then the inspectors get a third inspector, and that inspector is definitive whether an item is defective. It takes a little bit longer, but it's a much more clear process. Under NABOR, there's no procedure for dealing with discrepancies in the inspection reports, and the parties really just have to hash it out. Big difference actually between the contracts related to permits, going back to Stephanie's question. You can have up to 10 days for an extension of the contract for final inspections under FAR for permits. Whereas NABOR, you don't even have to get the permit inspection. As long as you start the process, you may not get it back from the county until 5 days before closing. But there is no extension. So if you do find open permits 5 days before closing under the NABOR contract, you can plan on doing a escrow agreement and escrowing 200% of the cost to close out the permit, which is another issue because you don't know how much it's going to cost to close out the permit until you get inspectors in there. So we can talk about that more under the NABOR and my NABOR class. Moving on, more inspection issues. So Under the FAR, the buyer notifies the seller within the inspection period for open permits and unpermitted improvements. The seller has to provide the documentation in the seller's possession, and the seller has 10 days to get estimates and deliver them to the buyer. And then the seller has 5 days before closing to get the permits closed, or there can be up to a 10-day inspection. And then if the costs exceed the permit limit, remember that 1.5% I mentioned a couple slides back, then the seller has to fix everything or the buyer gets a credit. So there is no right to terminate for inspection issues under FAR. Yes, Robin, I'll send a copy of this after the meeting. Under NABOR, the buyer gets to conduct a permit search within 5 days of the effective date, and the permit election is extended until after the permit search is received. So under NABOR, when you do your NABOR contracts, you have to get your inspections done, deliver your inspection election notice, and then the seller has to respond within 10 days, and you get one election. Well, you get one election for everything else, and then you can get a separate election under NABOR to get the seller to close out open permits. And the seller gets 10 days to respond to your open permit request, but they do not get to extend closing like they would under FAR. So the permit issue gets pretty crazy pretty quick under both contracts. And when I do my FAR and my NABOR classes, I get into much more detail on how to resolve these issues. But just to make you aware, really the big difference between the two contracts is you get an extension to close open permits under FAR and not under NABOR. Under NABOR, you do an escrow. Okay. Force majeure and risk of loss. These are some major differences between the contract. First of all, FAR actually has a true force majeure clause, whereas NABOR does not. You have to use reasonable diligence and be unable to overcome the force majeure event in FAR, and you close the contract within 7 days after the event passes or the closing date, whichever is later. And you can get up to 30 days past the closing date in FAR to for the hurricane or for the casualty event, for the force majeure. And the new Form 6 that you're all using now under FAR actually specifically includes pandemics. Let's see here, we have some questions. Helen is asking, for new construction, does cracked, broken roof tiles, are they cosmetic or defective? Helen, this is a great question. So I'm going to go back to that real quick. First of all, under both contracts, do not use them for new construction without a proper addendum saying that you're doing new construction and having all that spelled out. It's very frustrating for closing agents trying to do new construction when sellers and buyers are trying to do inspections and there's no standards for a new construction inspection. You're using resale home inspection standards. So just as an aside, before I get back into the force majeure, don't use these contracts for new construction without a proper addendum. All right, so we're talking about force majeure and risk of loss for FAR. Under NABOR, again, there is no force majeure clause, but if there's a casualty event, fire, flood, hurricane, then the seller has to put the property back as it was up at the effective date of the contract. The buyer can delay closing or terminate if the property is uninsurable. They have to close 5 days after coverage is available or the closing date, whichever is later. And under NABOR, you get an extension for risk of loss for up to 30 days after the casualty event. So this is a big deal because in Ian, the casualty event was, I don't remember the date exactly now, but on that date, when the hurricane came through, you got 30 days after that to close, whereas under FAR, you could extend for 30 days past the closing date. So you gotta be mindful of your time periods. Okay, Sorry to interrupt everybody with the other inspection questions during force majeure, but does anyone have questions about force majeure? Okay, seeing none. Vicky is asking, if an item is not permitted at all, how would you know if a permit was never applied for? Vicky, that's a great question. If somebody remodels their kitchen, never gets a permit, and you walk into a house and see a beautiful brand new kitchen, how do you know that it was permitted or that it was done to code? You need to get a code enforcement inspection. Those take several weeks to schedule and are very impractical in our quick closing time period that we're in right now for contracts. But that's the answer, is you would need somebody who knows the codes to come in and say that plumbing is wrong, that that electrical is incorrect, you're missing GFI switches, things like that. So you would have to get a code inspection. Okay, moving right along. Time is of the essence. Major difference between the two contracts with time being of the essence. In FAR land, time is of the essence for each and every deadline in the contract. You cannot miss any deadlines. You can't miss your deposits. You can't miss your inspections. You can't miss the closing. You can't miss the financing. You can't miss the title. Whereas under NABOR, time is only of the essence for the closing. But think of this, if you have a deadline in the contract that says 15 days for inspections, and then you, on the 16th day, you ask for it to do an inspection, the seller does not have to allow you to go in and do an inspection on the 16th day. So while it's not specific that time is of the essence for that deadline, in essence, time is of the essence for most of your deadlines in the FAR and NABOR contracts. Where this really comes up is in when you have to make your deposits. We see a lot of deposits where it's three days to make your deposit, and the contract was signed on Friday, so the deposit is due on Monday, and we get the wire instructions out over the weekend, and then the buyer's trying to figure out how to get to their bank on Monday morning, and lo and behold, we don't get the deposit until Tuesday. Well, under NABOR, that's okay. Under FAR, the buyer breached the contract, and technically they owe both deposits to the seller immediately, and the contract is terminated because time is of the essence for each and every deadline in the contract. So between NABOR and FAR, obviously NABOR is much less harsh in that regard, but at the same time, deadlines produce results, so it's not terrible. And the courts have recognized this. The Natchitoches Court versus Pickett case says the deposits are so important in the contract anyways that you shouldn't miss them regardless, and it essentially makes time of the essence for deposits, whether you have it in the contract or not. If you miss the deadline under NABOR, the seller's got to give notice of the default and an opportunity to cure for non-closing deadlines. So it's a little bit of a different process, and you need to get your favorite closing attorney involved quickly. Okay, questions about time being of the essence? See here, check the chat. Stephanie is asking, in Collier, if the work is completed by the owner and it doesn't need a permit as long as it wasn't moved to the original spots, not to exceed the dome. Has this been an issue anywhere? Stephanie, I'm not aware of any code in Collier County or the city of Naples that says that you don't need permits for plumbing and electrical. You have to have permits. You can do it owner builder, but you must have permits for plumbing, electrical, mechanical, and structural, no matter what. So even if you don't move stuff, you probably still need a permit. Like if you change a water heater or something, you definitely need a permit. Okay. Moving right along to default and dispute resolutions, the differences between the two contracts. Under FAR, all deposits go to the seller if the buyer defaults, regardless of whether they were made or not. So if you default on the first deposit and miss that deadline, under FAR, you owe for both deposits immediately. So be very careful. Under NABOR, the seller's only remedy is deposits made. So if you make the first deposit, decide you don't want the property, and terminate the contract, even though it's an improper termination and you're in default, the seller can only get your first deposit. So it's an interesting quandary, which contract is better in this regard. Obviously FAR puts more onus on buyers to perform, whereas buyers have less incentive under NABOR. So it depends on your situation, if there's financing involved and the condition of the home or the condo. But I think that the seller needs to be on alert to make sure the deposits are timely made and put the buyer on notice if they don't make their deposits. Under FAR, the seller must sell if title is marketable. That's the same under NABOR. So if the seller defaults and doesn't sell and the title was marketable, that includes paying any monies due at closing, then the prevailing party is probably going to be the buyer, and they're going to get their attorney's fees paid under both contracts. One thing about FAR is when you get into a deposit dispute and the title company is dueling demand letters, you're going to have mandatory mediation if the parties don't settle. And that's obviously a cost. So the goal is to get the parties to settle within 10 days, or you have to go to mediation under FAR. And with that, those are the major differences in the contract. I'll take questions. You can either unmute yourself or you can put them in the chat. Any questions?
I have a quick question.
Sure, about you.
So like you said, for new construction, there should be an addendum, because oftentimes it's not a major builder. So it's a person that had somebody build a home on that lot. And now they're using an as-is contract. Is there an addendum in particular for a FAR contract that we can use, or we just have to make one up? And what would it say?
You really need an attorney to draft a comprehensive addendum that covers what's included, what are the standards for inspections, the walkthrough, the punch list. I run into this problem all the time, Batya, where buyers want to give the seller, if they've signed an as-is contract, and they want to give a punch list and have the seller fix all these cosmetic items. It's a new home. You want a nice new home. You want the light fixtures to be straight. You want the walls to be free of scuffs. You want the baseboard to look good. And there's just no standards in the FAR or NABOR contracts for those items. So you want a comprehensive addendum to the contract, or a fresh contract, really. It's really the best practice is to have the attorney. I have forms for this, so it's not expensive. But get a fresh contract or an addendum to the FAR or NABOR as is for new construction. Don't be naked, as we'll say, with the regular contract on a new construction. You're not going to be happy at the end. Okay, let's see here. We have some questions. Debbie, would you recommend using the appraisal contingency with the NABOR contract the buyers obtaining financing? You do not need the appraisal contingency under NABOR or really under FAR either, because the appraisal should be done up front right away as soon as possible under both contracts. And then under NABOR, you just don't waive the finance contingency until you get the appraisal back and it meets with your approval. If it doesn't meet with your approval and you're not going to get financing, then you can terminate under either contract. Mia says, which contract is most used? Is it recommended to use one over the other if representing the buyer? Mia, that's a great question. Vivian's asking a similar question. So I never say that one contract is better than the other. You have to understand the specific situation. The number one most used contract in the state is the FAR as is. But I'm down in Collier County where we have the NABOR contracts. If you're up in the Northeast, you might see the NFR contracts. And then of course, the Florida Realtors puts out the CRISP forms. So the buyer needs to worry about if it's cash. I would typically make an as-is offer under either contract. If it's financed, it depends on the buyer's situation. Is this going to be an easy financing? Are they doing an 80-20? Are they doing FHA? Because then I might look at the NABOR contract and want as long of a approval period as possible, finance contingency period as possible, so that I get as long as time as possible to get through the FHA process. If it's like a 50% down thing, it's gonna be easy, just doing some financing, then either one works. Is there anywhere that realtors can purchase HOA docs? Cheryl, I hate to say this, but Google that one because I'm not sure. I think there is a website where you can get some documents if the association participates. And what I can do, Cheryl, is if you email me separately, I'll go ask my staff. I think it's like Real Docs or Res Docs or Doc Res or something like that. But I believe there is a website where you can get some HOA documents. Greg is asking, when a title company receives a residential resale contract to close, may they charge the seller a closing fee? It depends on the contract and the county, Greg. In Lee County, when the seller is picking and paying for title, they pay the fee and the buyer doesn't pay. In Collier County, if you're on the NABOR contract, which is pretty typical, then each side would pay a fee. Dustin, I don't always sell in Collier, but I've heard a lot of properties do not have mineral rights. How is this? And would you find out if it had mineral rights or not? Dustin, so that's a little bit outside the parameters of this presentation, but quickly I'll just tell you that the Collier family reserves pretty much all the mineral rights in Collier County, and you would find that out on the title because there's a reservation in prior deeds. So you have to look at your title policy for that. Roberts, can the title company get the recorded docs? Yes, Robert, we can get all the recorded documents in the state. We order them through our underwriter. It takes 2 business days and it's free. Judith is asking, do you recommend using a force majeure casualty loss addendum on the NABOR contract for either buyer or seller? Judith, I don't know. I've not actually had a problem outside of Irma and Ian with either contract and force majeure, and both contracts worked just fine in those storm events. I think in the case of FAR, it's a little bit easier because it just says that everything is paused, whereas under NABOR, you have to look at the casualty loss and the dates a little more carefully. But I don't know that you need a force majeure addendum in NABOR. Casualty loss, certainly not, because it's all covered in the contracts. Rosemary's asking, I did have a spreadsheet comparing the contracts. I'll have to find that, Rosemary, and come back to you on that. Connie says, under the inspection clause, is the permit search always done by the title company? Connie, in my office, we always do a permit search as part of our lien search. If there's time and if it's especially if it's a finance deal, but you can always ask for a specific permit search, just email me and I can go into the permitting websites and help you look up open permits. The bigger question is, and it was asked earlier in the chat, what happens when there's unpermitted improvements that nobody knows about? There's no permits to look up, so there's no open permits. But what do you do when it's a new kitchen or a new bathroom? Well, you need a permit inspection from the county. Marissa says, can you bring back the last slide for a second? Yes. The default resolution. Okay, Stephanie, can you send the language in the building code? Yes, Stephanie, shoot me an email on that. I'll take a look at it. Yes, Teresa, we always do a permit search and we look for code violations when we get our lien search. Okay, let's see here. A few more minutes. Does anybody else have any additional questions? Feel free to unmute yourself or put them in the chat. Guy is asking, this is a great question, guys. The seller compelled to disclose no permitted improvements? The guy, if you have an unpermitted improvement, the seller is absolutely obligated to disclose, or it's probably a Johnson v. Davis violation. Francis is asking, have you noticed counter permit departments are backed up? I've not noticed a backup, and we do our own permit searches most of the time, so it's not a big issue. Bob is asking, what about the dispute resolution or NABOR? Bob, under NABOR, if you can't work it out, then you sue each other. It's pretty simple. Judith is asking who should complete the inventory list and is it required? So Judith, that is a great question for both contracts. If you're going to sell a home furnished, please use an inventory list and attach it to the contract, or use the inventory addendum in NABOR so that you can get an inventory done. Otherwise, we're scrambling at the last minute to put a bill of sale together, and it just makes a mess for everybody. And Mary Ellen is asking, are there fines to a seller by the county for code inspections after no permit found, or after a permit's found for unpermitted work? Yes, there are fines, big fines. Farbar as is, any opportunity to request repairs or credits if it's a significant and dangerous electrical issue. And so if you've got anything in an as-is contract, you can request. It's a free-for-all. If you go in and you don't like the color of the tile or the paint on an as-is contract, you can request that it be changed, and you can terminate if they refuse. Let's see here. Denise is asking if you have listing, what contract is best? Denise, again, it just depends on the status of the buyer and the seller and what they're trying to do. Wendy, we do the whole state of Florida. All right, everybody, it's about that time. I really appreciate you tuning in. If you have any questions, you can call, text, or email me. My information is on the screen. I'm going to email out the slides and a link to the recording in a little bit. So feel free to use those. Thank you all very much for your time today.
Thank you, Sam.
And with that, we are out of here. Talk to y'all soon. Thank you.
Thank you so much.